Good day, viewers. I'm Okochapi Marcel, and this is my channel. As you all know, the actual hearing of the case between Peter Obi and Tinubu has commenced on Tuesday. And on Wednesday, they adjourned the case to today. So the court is going to sit today, and I'm going to give you the update of what is going to happen today. So yesterday, the case was adjourned because some lawyers were ill, and the sickness is enough to adjourn the case. So there is no necessary thing that they did yesterday. So today, as I'm talking to you, the suit is going on. But there is something very, very important that you need to know about the case that happened on Tuesday. And Kenneth Okonkwo is here to tell you what you need to know. Very important. Listen to him.
Commenced the pre-hearing session from 8th of May, and by 30th of May we commenced the actual hearing. The actual hearing commenced yesterday, where we produced fantastic witness through which and through whom we tendered our evidence on the drug trafficking offense of the second respondent, who is Bola Tinubu. Then we tendered our evidence on the non-qualification of Bola Tinubu as a result of double nomination of Shetiba, which is there in black and white. As at 14th of August 2022, he held the Borno Central nomination candidacy of the senatorial election and the vice president of Nigeria.
I thought the Supreme Court had already decided that question.
Your thinking is absolutely wrong. The issue before the Supreme Court was an issue of pre-election matter. And when you say you don't have jurisdiction to entertain a matter because the party has no locus standi, it means everything that is before the court, no matter how articulate it is dead. So, to my understanding as a lawyer, what the Supreme Court said was that PDP had no locus standi to challenge the pre-election matter in APC because it has to do with their primaries. That's why you use the word aspirant when you're talking about that. But let me talk about the obiter. Maybe a judge may have made an obiter. That's what we call it in law. His own opinion. Maybe saying something about writing to a party or something, you know. Excuse me. When you nominate a candidate, the nomination can only be valid when the list of candidates is published by INEC and released to the people. Then it's no longer a party thing. Is it not? I'm sorry to use the word, but I'm looking for a better word. Does it not disturb you for somebody to claim that mere writing to a political party makes you to have withdrawn? No. Until it gets to INEC, and INEC specifically strikes you out. In other words, you have withdrawn, because we're talking about candidacy. We're not talking about you aspiring to power. So the evidence we produced is to the fact that in INEC, which is the only commission that organizes the election, as at the 14th of that month, he held double nomination. And no evidence, for now, has been tendered to contradict that. So we are now in post-election matters, and you can distinguish it from the pre-election matters. We have the requisite locus standi because he challenged us in the general election. And when we adduce our evidence and take away their evidence during cross-examination, you may just see that we have complied with the law. And I am talking as a party to the suit, subject to the pronouncement of the court.
And on that extraordinary note, I want to say thank you very much indeed. It's always a pleasure listening to you articulate your position very confidently. Kenneth Okonkwo is a Nollywood star, lawyer.